How can I recover family assets if I believe other relatives are trying to keep me from accessing what I'm entitled to? In most cases, the first step is figuring out who legally owns the asset and which process controls it, because family assets are not always estate assets. If the money was owned only in the deceased person's name, it is usually an estate asset. That means the court-appointed personal representative, also called the executor or administrator, has the authority and duty to identify, collect, and report those assets through the probate file. Banks often will not confirm or release account details to other relatives, especially if you do not have account numbers. So the practical move is often to get the right person appointed and then have that personal representative make written requests using the court-issued Letters Testamentary or Letters of Administration. If the account was joint with rights of survivorship or had a payable-on-death beneficiary, it may pass outside probate directly to the surviving owner or named beneficiary. That can change what you are legally entitled to, even if the family expected the money to be shared. In some situations, the personal representative can still have limited rights to collect from payable-on-death accounts, but title and beneficiary designations matter. If the funds were turned over to the state as unclaimed property, you can often recover them by filing a claim with the Unclaimed Property Office and proving your identity and your legal right to the funds, such as proof of relationship or proof of estate authority. This can work even when a bank will not share details. Finally, if recovering the assets depends on challenging a will, there can be a deadline. A common time limit is 3 years after a will is probated in common form, with important exceptions, so do not wait to get advice if a will dispute is part of the problem.